President, please be seated. The court is back in session. As the chamber informed the parties this morning, before the chamber gives the floor to Judge Lavange to resume his questioning on the witness to TCW 918, the chamber will give the floor to the defense team to make the responses to document E319/32 in relation to the request to admit in a record of interviews on the Vietnamese treatment. Concerning the matter, the senior legal officer of the trial chamber informs the parties by email dated 12 November 2015 that if parties wished to respond to the request by the international co-prosecutor, the parties are allowed to make oral submission on the 1st December 2015. In the same email, the senior legal officer states that if other parties do not wish to make the responses, they shall inform the chamber by 20 November 2015, and no parties said that they do not wish to make the response. That is why the chamber will allow the floor to the parties to respond to the request. Before the chamber gives the floor to the defense team to make the responses, the chamber will hand over the floor to the international deputy co-prosecutor to make a brief background on the matter, on the request. You may now proceed, international deputy co-prosecutor.
Thank you, Mr. President. I'll be very brief on my opening remarks. I think the motion is fairly straightforward and is the same type of motion we've made with respect to other new statements that were authorized for disclosure from the other investigations. This particular group is a group of 25 interviews that relate primarily to the issue of the treatment of the CHAM. Some of them are trial witnesses, others are not. The relevance is set forth in our annex, both a description of the documents and the specific issues of the closing order. In terms of 87.4, as stated in our motion, these are documents, evidence that arose after the start of trial. More importantly, as the trial chamber has confirmed in recent rulings, it's the date of authorization by the international co-investigating judge in this case that is the date the evidence first becomes available. And for all of these documents, those are dates in 2015 when the documents were authorized by the international co-investigating judge to be disclosed. So I'll obviously respond to any specific points that the defense may have, but that is the basic grounds for our motion.
President, thank you. Do you have anything to address the chamber? And Guisse?
Oui, Monsieur le Président.
Yes, Mr. President. In agreement with my colleague Copé, if you would agree with us, I would start.
President, thank you. What about call it lawyers for civil parties. Do you intend to make submission on the request by the International Court Prosecutor regarding document E319/32? Page on. Thank you, Mr. President, Your Honors. Call it lawyers for civil parties do not have any objection to the request by the International Court Prosecutor. Regarding the documents requested, they are related to the Vietnamese treatment. And the documents have been placed on case file 002 with the authorization of the co-investigating judges. So we do not have any objection, and we ask the Chamber to consider and decide on the request. President, now I will give the floor to the defense team for the accused, and as mentioned by the defense for Mr. Kieu Sampon, the defense team for Mr. Kieu Sampon will start first before the defense team for Mr. Nguyen Jie. So you have now the floor, defense counsel for Mr. Kieu Sampon.
Merci, Monsieur le Président.
Thank you, Mr. President. As regards these 25 new WRIs of witnesses which the International Court Prosecutor would like the court to admit into evidence, I would like to start with the documents we do not object to, and I would explain to you why. For ease of reference, I will use the annex of the Court Prosecutors E319/32.1, and we'll be looking at the numbers on the table, so we do not object to document number 4 on the table. And the reason is simple. That document has already been tendered into evidence. The number is E39350. We do not object either to number 2 of the document on the table, document E319/24.3.3. This is the record of interview of a witness who has already appeared, and that is TCW 950. We do not object either to number 19 on the table, that is document E319/19.3.95, since this witness has been called to testify soon. So logically, when witnesses have appeared or are due to appear, their prior statements have to be admitted into evidence by the Chamber. For the remaining records of interview, the Kieu Sampon defense objects to tendering to evidence these documents for various reasons. According to Rule 87 or 87.4.3, we consider that these rules have not been abided by. Let me remind the Chamber that there's something we often forget. With the mass of documents that we would like to tender into evidence on the basis of Rule 87.4, that particular rule is exceptional. These documents are being admitted into evidence in the course of proceedings. This should not be the case, whereas there has been an investigation, so it should be done at the beginning, not during the proceedings. So the documents whose disclosure is being requested should be relevant to the manifestation of the truth, the ascertainment of the truth. So they are trying to tender into evidence written statements in place of oral testimonies, and the Chamber should attach very low probative value to these documents because the witnesses in question will not be cross-examined by the parties, particularly the defense. And secondly, in this particular case, the problem is all the more serious as regards probative value because in the investigations, we do not even have any recordings of what the witnesses said, which means that we cannot cross-check the contents of these statements, whereas that would have been done in the past as part of investigations. And then, this is perhaps the most important point, the reasons given by the co-prosecutors, for the international co-prosecutors for their application is particularly tenuous. We are being told generally that these documents are relevant to the segment regarding the charm. It is not in line with Rule 87.4. Under Rule 87.4, and I'm reminding you of the case law of the court, particularly your memo 131.1, page 4, the last but one paragraph, and your memorandum E118/4.3 or point 4, last but one paragraph, you stated that the applying party should show that the tardy application for admission of evidence into evidence, it should be shown that it was essential and crucial and in the interest of justice. That is not the case in point. We are being asked to admit into evidence written documents as opposed to oral testimony for limited probative value. These statements are neither essential nor crucial in the interest of justice. Another reason for which we object to these statements being admitted into evidence is the lack of diligence on the part of the prosecution. In this case, you recalled in a memo E319/30/1 in paragraph 3, that was on the 15th of September 2015, that the chamber was expecting the parties, and I quote, to show proof of all due diligence and that it should address to the chamber in a reasonable time all documents they would like to have admitted, as well as the documents that have to be admitted into evidence. This is what you stated, and it is in line with the rules, and it is also logical. Now, the application by the co-prosecution or co-prosecutors that new evidence be admitted on the charm segment, this application by the international co-prosecutors was made when the segment on the charm had already started, which means that they haven't exercised due diligence in this matter, and that is why the application should not be granted. There is also a lack of diligence, due diligence, as regards the very contents of the statements of the witnesses that the prosecution claims that their statements are very crucial and that the chamber should admit them. I'm taking 3 examples. The co-prosecutors knew well before the beginning of the trial the existence of the witnesses that they today deem to be very important. Let me give you a very specific example, and that is witness 2 TCW 987. The co-prosecutor is asking that the record of interview of this witness be admitted into evidence. Let me remind the chamber that when the chamber, proprio motu, wanted this witness to be summoned to appear, we objected to that in our submission E304. In any case, as regards the co-prosecutor's application, we would like to point out today that that witness may have been discovered as part of case 003, but that is not true, because since 2008 the co-prosecutors have been aware of the existence of that witness, and I'll refer you to documents from the Office of Co-Prosecutors, and these are document E3/7807 and E3/5302, and These are documents from the Office of the Prosecutors as of August 2008, and they had already mentioned that witness to TCW 287. So they were able to obtain materials regarding that witness, and they should have had that witness interviewed at the time. So it is not acceptable that at this late hour they are requesting that those statements be admitted into evidence. Let me also recall the recent decision of the Chamber E363.3, paragraphs 7-9, in which the Chamber points out that any party requesting the tendering into evidence of new elements, and the Chamber was referring to the prosecution, it should show that the evidence referred to could not have been discovered in spite of the exercise of due diligence. To take the particular case of 2 TCW 287, we find that this person was referred to several times by the OCP, so I cannot understand how they can claim that due diligence has been exercised. And it is for that reason that we are of the view that the application by the co-prosecutors should be rejected. Another example is that I will refer to all the objections we mentioned in E364. Another example that shows proof of the lack of due diligence by the Office of the Co-Prosecutors has to do with the record of interview of a civil party, document E319/19.3.203, and here again we are dealing with a civil party whose record of interview ought to have been made available as part of the 002 investigations. If the co-prosecutors had considered that that person's testimony was so important, that civil party's application should have been on the case file, and they would have asked the co-investigating judges to interview that civil party as they would have done with other witnesses and civil parties. They didn't do so, and today they are saying that that person's testimony is so important that they should introduce that person's statement from another investigation. That is not true. They knew of the existence of that person well before. That person's statement is in case 002, and if they had considered that that person was very important, they should have requested that the person's statement be admitted into evidence. They didn't do so, and it therefore showed lack of due diligence. They also showed lack of due diligence in the case of the previous civil party. In document, the application E3/8667, it was in on the case file before, and if the co-prosecutors had considered that that statement was all that important and that they wanted to call that witness to be interviewed as part of the investigations, they should have done so. They didn't do so, and they showed proof of lack of diligence, and today they are saying that they should use statements from another investigation and to have that statement tendered into evidence, and they are doing so tardily, so we therefore request that that application be denied. I would like to recall again your memo E363/3 on paragraph 30, in which you recall that it is only exceptionally that evidence that does not meet the criteria laid down in Rule 87.4 can be admitted. Under the current circumstances, those rules are not satisfied. So they are not in line with the instructions laid down in your decision. Lastly, for a number of statements we find that they are of a repetitive nature, as referred to in Rule 83. In principle, they are saying that we should admit into evidence these records of interview that have to do with the charm, and we've had so many statements or witnesses regarding the charm, and there are many other witnesses who will be called to testify, so I do not see why that document will be essential as part of this trial. At this stage, we therefore consider that such statements are repetitive, particularly with regard to a number of subjects, particularly forced marriages and purges in the Southwest Zone, purges of cadres in the Southwest Zone. So I think they are overloading the file, and I think at this stage we should consider that there's a lack of diligence, and it is not useful to tender into evidence these documents. And lastly, we have the witnesses, and on the co-prosecutor's table, we have E319/32.1, number 13, 16, 11, and 12. If we consider that the witness I referred to initially is one of those whose statements they would like us to admit in advance, and this witness could eventually be called to testify, but the chamber has not ruled on that matter. Under these circumstances, we consider that this application is premature. If that witness had to be called by the chamber, in that case, quite obviously, given our position, which is very logical, we do not request that the chamber tender into evidence these documents, insofar as that decision has not been made by the chamber, and we are not sure that that person will come before this chamber. And since it's possible that this person may come before the chamber, I would request that the chamber should not admit into evidence those the application or grant the application of the co-prosecutors. We shouldn't forget that Rule 87(4) is a rule that is applied exceptionally, and it shouldn't be the rule. And we find that the co-prosecutors are making it a rule, and that is why we ask the chamber to reject the application.
President, thank you. Now the floor is given to the defense team for Mr. Nguyenchi, if you wish to make any response.
No, thank you, Mr. President. That was quite exhaustive. We have nothing to add. Other than, if you allow me to take the opportunity that to ask you, or to remind you rather, of a pending motion from our side in respect of 6 witnesses in relation to the treatment of the charm segment. That was E370. We filed that request on the 29th of September, and we are still waiting for an answer. So hopefully soon you will come with a decision when also deliberating on the issue that we just discussed. Thank you.
President, you may proceed now, International Deputy Co-Prosecutor.
Thank you, Mr. President. I'll do my best to respond. There was a lot of document numbers being going by quite quickly there, so some of them I may not have accurately recorded. Let me do my best that I can here. First of all, I would note it is correct that since we filed this motion, one of these statements was admitted because it was a document that had been requested by the defense. That, again, this happens quite often here. There are many documents that have information that we consider to be of importance to the court and the defense considers to be of importance to the court. There were others that were not objected to because they were trial witnesses or selected trial witnesses. I'm not sure why counsel is distinguishing the witness and I don't know if I got the number right, 2 TCW 987, but I believe they're referring there to the witness who's, we have two statements for here, statements 11 and 12 is the witness that was selected sua sponte by the trial chamber to appear. So it would certainly seem to me that those statements would should be admitted pursuant to the logic of counsel. The arguments about the weight and probative value are arguments just that go to that. They are not arguments that go to admissibility. This court has set out very clear rules based on international precedent about the weight and use that may be made of statements of witnesses who do not appear. So this is not an argument that goes to the issue of admissibility. The issue of some of the standards cited by counsel, there was some fast and loose arguments being made here that merged and confused the rules that have been set by this court. And what I mean by that is that counsel was citing to some standards that have been announced by this court where the requirements of 87.4 are not met. And in cases where 87.4 is not satisfied, documents can still be admitted that are on an exceptional basis, that relate to documents already on the case file. And that was the standards that counsel was citing. Those standards have no application here because these documents clearly, under any interpretation of 87.4, meet the criteria. There is no question about that, that these are documents that came into existence after the start of trial. And that is another distinction that was being ignored in counsel's argument. There's a difference between knowing of the existence of a witness and having a new statement from that witness. The issue here in terms of admissibility of statements has been set by Your Honors. It is not the fact that we knew a witness existed before. There are many witnesses who exist. The issue is, when did this particular statement become available to case 002? And Your Honors have made very clear in the recent decision that counsel cited repeatedly, and I'm talking here about E363/3, your 22 October 2015 decision, and referring to footnote 64. This is a footnote in the section about what documents are considered to be, when they're considered to be available. And this is what you ruled, quote, "Evidence from the confidential investigations in cases 003 and 004 is unavailable for the purposes of Rule 87.4 until the Office of the Co-Investigating Judges authorizes the co-prosecutors to provide it to the parties in case 002/02. So under your own rules, these documents did not become available until authorized for disclosure, which were various dates. The earliest, I'm looking at my computer here, April or May, others in August, and some later than that. So under the terms of 87.4, there's no issue about that. They've argued diligence as well. Let me just say this. The Chamber established a deadline in this very decision for when we had to file 87.4 motions for statements that had been disclosed prior to September. You gave us until the end of January, 30 January 2016. This motion was filed well before that. It was filed, in fact, well before this decision even came out. I would submit that there is no question of diligence here. Counsel is suggesting that because a witness's name, and I think she was referring here to the witness that Your Honors selected sua sponte, this is a person whose name came up This is a person whose name came up during a preliminary investigation. It was not someone that we were able to locate and interview ourselves, and it was only in the course of the investigating judge's investigation that this person was located and interviewed. This person gave 2 interviews. If you read the first one, it was a very short interview that had to do with a security office and not about the CHAM. The second interview is the one where the witness, the recent one, is where this witness was interviewed about the CHAM and had probative things to say about that. That is why Your Honors presumably selected this person. And the reason we included both statements in our 87-4 motion is because this is a person that had been selected by Your Honors to testify. So even though that earlier statement is in our motion, it is in there because of the fact you selected this witness. That earlier statement itself doesn't talk about the CHAM, so just so that is clear. The repetitive nature of evidence, we have the burden of proof, a very high burden of proof. We have defense teams who are actively challenging us on every single issue here and at the appellate stage. We all know that these witness statements are used primarily for corroborative purposes for witnesses who do not end up appearing. That is a legitimate use of evidence, and these statements should not be rejected as repetitive, where a prosecution has a burden of proving things beyond a reasonable doubt, and corroborative evidence can assist that, because we all know that you cannot hear every single witness who has knowledge about these matters. So I've done my best to respond to the documents I was able to keep notes of. If you have any questions, I'm happy to respond.
President, thank you. And case upon defense is given the floor again to a response to the reply by the International Deputy Co-Prosecutor. You may proceed.
Merci, Monsieur le Président. Je ne serai pas très long.
Thank you, Chair President. I won't be very long. But on the issue of TCW 287, as far as I know, there has not been a decision rendered yet on E364, which we filed. The prosecutor said a bit quickly that you had chosen. However, we are still waiting on a decision on our writings, on our filings on the matter, and therefore I maintain my arguments on that matter. Now, on the fact that I couldn't bring the argument that it was tardy or lack of diligence because some statements were not available before, even though the prosecutors knew of their existence. Once again, I must go back to our protestations of the last few months. Again, I see that the prosecutors use investigations 3 and 4 to fill up investigations that they never asked for or points on which they didn't insist in the case 2. And again, I would like to note, and I will repeat it, that it is not a way to proceed in the context of a trial. 87.4 is for exceptions and not to fill gaps that were not done in the first investigation. Thank you.
President, thank you for all comments and observations made by the parties in response to the International Co-Prosecutor's submission, that is document E319/32. The Chamber will use all your comments and observations as grounds for our decision. And before I hand the floor to Judge Lavang, I'd like to inform Mr. Copper That is in relation to your document E370 to request an additional witness. The Chamber is deliberating your request, and a decision will be issued as soon as possible. That is before we proceed with the facts in hand. I'd like now to hand the floor to Judge Laverne to put further questions to the witness. You may proceed, Judge Laverne.
Thank you very much, Mr. President. Good afternoon, Mr. Witness. I will try to pick up where I left. I would like to come back to the issue of the list of people to be arrested. You told us that Ta Rin showed you this list, that he was Ta Val's replacement. And you said that there were 100 names on this list, 100 names of people to be arrested. According to you, could you tell us who gave this list to Ta Rin?
Regarding the list of names, I did not know who actually delivered it to Ta Rin. And the names on the list were several, but it was not up to 100 names. Again, let me repeat that I did not know who delivered that list of names.
In your WRR E3/9567, year in English 0 10 44 770, Khmer 0 10 03 843. You say that there are 100 names, and that you believe that it was Ta Chil that gave it to Ta Rin. Does this refresh your memory, witness?
Yes, that was my suspicion, and it was merely a suspicion. It's not the reality. I did not know who delivered the list of names to Ta Rin, and it was my thinking that it was Ta Chil who did that.
And do you know what happened to those people whose names were on the list? Were they arrested? What happened to them?
Later on, I also did not know who actually went to conduct the arrest. Some were aware of their fate, so they had escaped from their units, though I did not know where they had fled to.
And what about those who were arrested? What happened to them?
I did not know how the arrests were conducted. What I knew was that some people whose names were on the list had escaped, and I did not know about the process of searching for them and made arrest.
You have not answered my question, and so I will ask it again. those who were arrested, those who were indeed arrested, what happened to them?
Those who were arrested and put onto the vehicle while I was present there, I did not know what happened to them later on or whether they were sent to be killed. What I saw was that they were arrested and put on their vehicle and the vehicle drove off.
Est-ce que sur la liste
On that list that you read, were there names of people you knew? And did you see these people again?
I cannot recall that. What I can recall is a few names who were from my village, and the three men whose names I knew actually disappeared from that day.
You tell us that 3 people you knew had disappeared. They never reappeared. You have also said, and this is in your EWR E3 9567, you said that on that list there was one of your younger cousins. Do you remember seeing that? And what was that cousin of yours? What was his name?
បាទអានោះ
I mentioned those names, and that I only knew 3 names. One was my cousin by the name of Utsi, and the other 2 men, I do not recall their family names. One was Wat and the other one was Sre. And for the 3 men, I have not heard from them since the arrival of the Vietnamese.
vous avez
You have also said that another one of your cousins had been detained in the Phnom Troyong Security Center. Is it the same person? Is it a different cousin?
Regarding the detainee at Trajong Mountain was another cousin by the name of Tung Sơn. And when the Vietnamese arrived, I saw him returning to the village, living with his wife and children. And later on, he passed away after one of his children got married.
avant la
Before the Vietnamese arrived, you said in your WRI that you went to see him at Phnom Troyong. Is this true? Do you confirm that statement?
That information is correct. I did meet him.
pourquoi vous
Why did you go to the security center? Was it specifically to see him, or did you have other motives that led you to visit this security center?
អ The security center was located along the road leading to my fishing unit. So I went there to seek to meet my cousin Tum Seon, and I wanted to know what happened to him, whether he was cuffed or chained, and indeed I met him there. However, he was not chained or handcuffed. He was ordered to break a rock at that center.
In the WRI, you have also said that you often went to see your parents who were in the cooperatives. Am I to understand that, contrary to the other workers, you were able to move freely? Or did you, every time, have to ask permission to do those visits?
For my journeys, it depended on the nature. There were 3 locations where my office had staff. One was at Stang Kambot and Kbal Krop Bay, and that was near where my parents lived. Another location, known as Kinsbow, was not in the direction of leading to the house of my parents. And there was another road, as I stated earlier, leading to a location near the Trayong Security Center. Usually, I use these 3 routes to go to my unit.
And do you know of other security centers? Have you heard of other sites, such as Chamka Dong or Chamka Knoll?
No, I never saw it. Only after the arrival of the Vietnamese, I heard a song playing over a loudspeaker, and the song was sung about this Chamka Knau.
I would like us to go back to the Trapeang Tama worksite. To your knowledge, did it happen that workers would disappear from the worksite? Were workers ever asked to go follow a course, to go study, or to go help with transporting goods? Only never to return. Has that ever happened?
While I was working there at the Trapeang Tama Dam worksite, nothing happened. And after I left, I could not tell you whether anything happened over there.
Was there anyone tasked with spying on the workers?
No, there wasn't.
According to you, did workers fear for their safety?
I could not tell you about their minds, whether they were concerned about their safety. Although I met those workers in my unit, I did not know about their feeling, and I could not say about other workers in other units.
To your knowledge, were the working conditions, the living conditions on the Trapeang Tama worksite change after the Southwest Zone cadres came.
After the arrival of the Southwest group, I was at the fishing unit. However, once in a while, I returned to the dam work site with the fish supply, but I could not tell you about the situation there. What I saw was that the people working at the economic section did the same food and fish distribution.
This morning, you were asked a few questions on the testimony of 2 TCW 996. That witness had said that you could have participated to a meeting with Taval. That same witness was gave a WR E3/9076 when he was asked of the working conditions in his unit compared to other units in Trapang Tma. This is what he said. I will quote in English because the document does not exist in French.
Difficult. Even my unit also still had a hard time. We labored every day without holiday and feared to take a rest if we got an illness. We had enough rice, but we were lacking food. We had labor like animals. We didn't know when we might be arrested or killed. We could not ensure that we were safe. Plus tard, lors de l'audience lors d'une
later on, in another hearing, when he testified here in this courtroom, he said the following. Here I am referring to the fact that we didn't know when we would stop transporting soil. Every day we did the same thing, and when we finished one project, we moved on to the next. And we never knew when it would end. They were using us as cattle. This was the hearing of 27 October 2015, and this was said at 11:09 a.m. Sir, does this correspond to your memories of, did you get the sense that the workers were used as cattle?
While I was there, the situation was different from what this gentleman said. And after I left, I could not tell you whether the situation worsened as he stated in his testimony. I cannot tell you about that.
And when you were there on the worksite at Trapang Tma, were there any people who were sick? And if so, what illness did they suffer from?
Yes, there were. Workers were sick from dysentery, for example, or a fever. But they were not starved of food. There was a problem with drinking water, and for that sometimes they had a problem with their bowel. And that's what I saw on site. President, thank you. The chamber will take short break and return at 2:45. Court officer, please assist the witness at the waiting room reserved for witnesses and civil parties and invite him back with his duty counsel at 15 to 3. The court is now in recess.